Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? And people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see? Because he was the guy.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Good afternoon to you. Hope your lunch was fantastic. I had my Trader Joe's chicken fried rice, which I cooked.
You look good.
Well, thank you. I didn't follow directions. Apparently, I was supposed to put it in a non-stick. I don't have a non-stick pan. I just have like the chrome one that everything sticks to. So as I was scraping my lunch off the bottom of the pan, it was actually delicious. I like crunchy rice. It's good. I burned it. It was yummy. I'll have to try it again following the proper instructions. Yeah, I've got stainless steel. That's all I got. Big congratulations to, well, I have to fix those buttons one of these days. Big congratulations to Kim R, who won the internet yet again today. This is a twofer. 2 for 1. She won this morning and she won again. Congratulations, Kim. You're doing just great. You did great with the internet this morning. Keep it up. Keep it up. We're gonna be happy with you if you do that. So I hope you clean the pan. Well, sort of. What my idea of cleaning a pan, especially a stainless steel pan, is I keep it really hot and then I go straight to the kitchen sink and I just pour water in, and then it's like sizzle, smoke, steam, all that stuff, and then I sort of scrape the bottom. And it sort of mostly just cleans itself because it's sort of like boiling it off. So I did that, if that counts, but I haven't like washed it yet. I'm letting it soak for a bit. Plus, I've got one of those magic sinks where if you just put dishes in, dirty dishes, if you just step away and like come back, I don't know, an hour later, it's just poof, it's clean. I don't like talking about it because I don't like bragging, but I do have one of those magic sinks. So, all right. Welcome back. Yes, hubby has one of those as well. Yeah, see, he knows. There's a trick to making stainless steel nonstick. I feel like I watched a YouTube video. I think I just need a wok. I've always wanted a wok, but I just don't know. I just don't know. Everyone's outing me for Mrs. R.A. cleaning up after me. She does. A wok, like a double, not a walk. Greeners, not a walk. A wok. Wok. W-O-K. I need one of those because every time I've had real Chinese food cooked in a wok, it's tasted delicious, and it's probably the pan and not my lack of skill that causes that discrepancy. Walk in, walk out. There we go. Oh yeah, I call my dishwasher John. I'll get around to it. I'll get around to it. I really will. I want to invent a sink that's also a dishwasher, so you put stuff in the sink and then it closes and washes the dishes. I'm pretty sure, like, if you can have the kitchen that just completely folds up on itself and just everything gets clean, then it opens back and everything's put away, I would buy one of those. Hubby wants to know where he can get one of those magic sinks, and my wok is still sitting in the sink. Oh, yeah. Anyway, welcome, KT. Welcome back. Welcome. Good to have you here. DoorDash. That's the secret. Got an electric wok. It's great. I thought you needed fire. I mean, when you go to the Chinese restaurants, they like turn on the burner and it's like a, I don't know, medium-sized jet engine. You know, it's like flames flying everywhere, up around the edges of the bowl. Don't you need that? Splash some water in. dump it somewhere. I don't know where they dump it. They always like dump something on the stove somewhere. They must have like a drain back there or something. I want one of those, but I need like a wok holder, because woks are rounded on the bottom, and they would just roll right off my stove. I do have a gas stove, but I don't know. Do you have to like put like a wok stand there? Inquiring minds want to know. All right, welcome back. We're going to be coming back to the Karen Reed trial, which is it's actually a hearing. It's a pretrial hearing, as we've got a sort of a Daubert hearing going on, where we get to hear testimony from Dr. Russell, who is the dog bite expert for the defense. The defense wants to bring her in. The state is pushing back on that, wanting to challenge her testimony, saying she's no expert. You shouldn't listen to her about any of this. We don't want her coming in. We don't want the next jury to hear any of this confusing speculation. And so they're doing their very best, and I will say they're doing a very good job pushing against Dr. Russell and against her credibility as an expert in this area. But I think it's one of those you bring your expert, we'll bring ours situations. I think that's how it's going to end up. But I do think that the Judge Beverly is not going to make a ruling on this case today. I don't think she's going to rule from the bench on this one. She'll come out with a ruling later on. I think she'll allow it. She'll be like, I'll allow it. There's no way she's denied to testify. She has too much in the way of credentials and experience. And I realize it's a little different than, other scientific principles, but medical certainty, she's following the standard processes and procedures. I think it's good. DF held a motion that you're planning to ban the ARCA experts. Yeah, I saw that. Brandy's actually tweeting about that. She was pretty upset. Follow Brandy either on YouTube or Twitter. She's also following this one. It's a great one to watch as well. The fire is important. I have the fire rim to add to the wok. Directs the fire where you need it. Do I have to bring in? We'll have to have wok talk later on, possibly for the podcast. We can do wok talk. We can talk about all the customized cooking gear that we need. Sounds like a new Amazon toy. I have wanted a wok since I was a kid, but if I've more than wanting a wok, I've wanted someone who will cook in the wok for me since I was a kid. I have not found that. My mom cooked in a wok, and that was pretty good. But it wasn't until later in life I really started enjoying the variety of food that is available in life. I mean, I thought it was like peanut butter sandwiches, macaroni and cheese, ramen, and upside down cake in a bowl with milk. I thought that was pretty much all the food groups. But now I've really started enjoying a variety of food from different parts of the world, and the wok is tempting me again. Is Massachusetts just because it makes sense? It means absolutely nothing, says Late But Present. Yes, and so I can find the best cookware. There's some good places out there. Like you go to Orson Gigi, you can get some nice cooking stuff. Also for cooking for a lot of people. You have to have the correct wrist action. There's skill involved. It's not just something I can follow a recipe and it will be good. I don't think I have the correct wrist action. That's not an area where I've devoted much time and effort in my life. Cook every day for 7 people, says Karina. All right. How much do you charge? No, my wife does great. She's amazing. All right. Thank you, by the way. I don't know who it was, but somebody ordered some magnets. I saw an email that just came in. Thank you. We do have magnets. We have magnet stickers, and we have the rare, seldom seen. It was going to be limited edition, but we brought it back after popular demand. We have the 13th Addicts, which is the collaboration sticker commemorating Brandy Churchwell and our channels working together. It's a cool. Let me see if I can show you this one. I don't know what I can't show you on this screen. It's probably everything is my guess, but let me see if I can make this a little bigger. Hold tight. Oh, I was smart and reversed everything, so now it doesn't work. Okay, here we go. There are stickers. There's our 3 stickers over on Sticker Mule. You can either get the metallic Recovery Addict reflective sticker. We have the reflective So this is like silver reflective, so it's like shimmers like a rainbow. 13th Addicts. This one is 7 inches by 3 inches. It's massive. It's almost a bumper sticker. And then, so the 2 outside ones are 3 by 3, the square. This is a magnet. This is a sticker. All of it. That's what we have so far over in our Sticker Mule store. So it's all good. But thank you for whoever ordered. I don't know who. They don't tell me who ordered. They just say someone did. So somebody got some magnets, which is cool. All right. I have something to show off as well. I was going to show you this morning. I was late, so hang on. I got a present for Mrs. R.A.'s birthday. I mean, I got the present. I got a briefcase. I got a briefcase for my Starlink because we are planning on taking it to different courts, things like that. So we get to have good reception and coverage wherever we are in the world. And so the Starlink fits inside here. Actually, it's inside right now because we're not using it this very moment. There it is. Isn't that cute? And yes, it does have TYO Toys sticker as well as Sweetwater and Sticker Mule and my own sticker on it. On the back, we've added an identifying sticker as well, just a little cockroach. But that will help us to be able to keep the gear protected while we go out to on site with all our equipment. So, all right, looks like an etch a sketch. It functions about the same as well. You just sort of set it out there and does this thing. Got the Travel Starlink. I have the Gen 3 one. Absolutely love it. I got the Mini, which they dropped the price on by $200 like a month after I bought it. Starlink, the data, we do $165 a month for the data. But that gives us unlimited, and that in conjunction with the Live View with the 4 data modems combined together with the Starlink as well, should give us a rock solid feed. We could even push a 4K signal from just about anywhere. All my friends are saying I need to get an air fryer. I don't have one, but I guess I do. I just didn't know. I have a convection oven. When we redid the kitchen after my son destroyed it, we put in a dual oven, like a double oven. So the top half is small and the bottom half is larger. The bottom half is a convection oven, which is pretty much an air fryer, or so I hear. But you can't just like add oil and then throw stuff in there. It has to be in a pan and things. But so it's pretty much, I almost have an air fryer. All right, still waiting on the feed from court. We'll bring that to you just as soon as that's available. And we'll jump back into the hearing with Karen Reed, which should just be moments away for that. Some drone spotting on your travels. I have a drone. I've owned, if you count the small ones without cameras, I think I've owned 6 drones. My third drone was the DJI Phantom 1. No, the third one was an F450, which sounds like a truck, but it's actually a drone. And then I had the Phantom after that. Then I've had some other ones. But what does the trial actually start? I think it's, the 27th of this month? How soon does Karen Reed begin? I think it's the 27th of January. Shark, it's some frustrating times during this because this is like legal battles with a lot of snark, and if you don't like the person who's saying it, it can be hard to listen to. But I've really enjoyed the arguments and the angles of what they're trying to get at in this hearing today. It's off until April 1st. Oh, it's an April Fool's joke. Nice. Okay, so what was happening? Something's happening January 27th. Maybe there's a different trial happening. Day on the docket could tell us. You have the schedule. I like good lawyering. This is good lawyering, but it's snarky and like I don't. Can I not like the person and still at the same time be impressed with what they're doing and how effective they are? Because I think that's the boat I'm in right now with the state. Okay, it got moved from the 27th. I knew that date was stuck in my head for some reason. So 3 more months out. I think that was to allow for more time to review some of the expert material and the car chip off and everything else. I think that's what it was for. Can I get the destroyed kitchen story? Drama llama. Yes. When we moved into our house, it had a 1950s show kitchen. By 1950s show kitchen, I mean this kitchen was the best you could get in the 1950s. We had it. It had a 12-foot long stainless steel top, one-piece stove, dishwasher, sink, and cabinet that went along one side. The walls, around the kitchen, had metal cabinets that matched the bottom. So the cabinets were made by the same person who made the stove. Everything was metal. The refrigerator freezer hung on the wall like a picture, literally hung on the wall up above the countertop. All of it made by General Electric. Back in 1950s, they did this all-in-one kitchen, which was phenomenal. It was impressive. My youngest son, took a cup, stuck it upside down in the sink in the drain, and left the water running, filled it up, and it spilled water over the front of the sink. You think that's not enough to ruin, a kitchen like this, a whole kitchen set. But in fact, the front of the sink, right underneath, by design, General Electric had put all the breakers, all the power for all the units in there, and it shorted out, just about caught fire, and the flood also damaged the floor. It turns out we had to tear everything out. Insurance said, we'll just replace it with a like model. There was one like model available in the world of that, and it was in California, and the owner wanted $60,000 for their kitchen appliance. Now, it was a piece of junk, but that's the closest thing that we could match. And so they said, you know what, we'll just give you a new kitchen instead. And so we got all the way down to the subfloor, tore out the subfloor, put that in new all the way up. Granite countertops, took out the kitchen freezer that hung on the wall. We even tried to sell the old unit for parts or something else, and somebody in California wanted it, but they wouldn't come pick it up, so we ended up just taking it to recycling. But we called GE, General Electric, and we said, hey, we'd like to get parts for this if we can replace it. And they didn't even have records they had ever produced it. So they asked for photos of it from us. And you open the cabinets, it has the GE little sticker that's on your stove. It has that inside with the serial numbers and everything. They said, we don't even have a record of that in our system. So it was fun. We had the yellow color. I'll dig up some pictures and show you sometime. But we ended up getting a new kitchen out of that. We only had to pay for all the upgrades. And so the kitchen, which my wife absolutely hated, became her favorite room in the house. It just took about 4 months to do it. All right. When R.I. says his son does something, usually he means he did himself. No, this is my youngest. It was him. Was it a science experiment? No, well, I don't know why he did. How were the joists? The joists were good over there. That's the one room where the joists are good because it was an add-on. It was built in the 1950s, as opposed to the rest of the house. It was built in 1915, so it had 35 years newer on it. And this son is still around. Yes, it turns out we love the effect. I mean, we were beside ourselves when it happened originally. Because we had no kitchen, we had no place to prepare or cook food. The insurance put us up in a hotel. So we lived in a hotel for a little while. It was wild. It was a crazy time. Let's see. Trying to get this pulled up. Just 1 second.
The objection sustained asks the question differently.
Okay, I found the feed where we're at here. Let's see. Just started a minute ago. There's the fan. We'll pick up from about a few minutes ago. All right, there we go. Actually, let me speed this up so we get caught up to the minute. Does that work? Yeah. All right, so it's going to be 1.25 speed until we catch up in about half an hour.
Go right ahead, Mr. Lessing.
Thank you, Your Honor. Welcome back, Dr. Russell. We left off talking about pattern recognition and your pattern recognition methodology. Are there patterns to dog-inflicted wounds from civilian dogs?
Yes.
What are the patterns?
Civilian
there
dogs?
are several patterns. There could be just simple abrasions and grouped abrasions. There can be, depending on the depth of the injury, there can be what they call the hole and tear pattern. If the teeth penetrated through the skin, there can be a variety of patterns, including parallel lines and others.
Is there support in the medical literature for these patterns and your pattern recognition methodology?
Yes.
Can you name the authors of any peer-reviewed supporting the patterns and pattern methodology?
Yes, so the two come to mind right now, and one is written by Demunic and et al., and there's another one with Dr. Pollock et al.
And to help our stellar stenographer, Demunic is D-E-M-U-N-N-Y-N-C-K. If you could please turn to exhibit number 33 that is in front of you.
Yes,
let me know when you have that exhibit.
I have it.
Do you recommend? Is this the Demunic peer-reviewed article that you were just referring to?
Yes.
What I'd like you to do, Dr. Russell, is to
Hey, Laurie, send me a text on the burner phone. I'll reply to all
where
those.
in this article there is the rooting of the pattern and pattern methodology, recognition methodology that you've been testifying to. Where is it located? And with the court's permission, I'd like you to read the specific sentences and paragraphs where that methodology is rooted in it.
Tell us first, because if it's a whole page, let's just see where it is.
Okay. On page 298. The second paragraph on the left-hand side. Okay.
Your Honor, it's not going to be reading a whole page, it's just the portions of this. Is that acceptable
So
to
you
the
can
court?
read a portion of that paragraph, Doctor? Because what you're trying to do is convince me, right? And these
Understood.
are in evidence. So could you tell me where it is, please?
Okay. So
I like her
left-hand part is
1.25
the
speed.
second, the third, and the fourth parts. So it says dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower jaw. Usually the mandibular dental arch is narrower and shorter than the maxillar, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed.
And then if you could skip to the next paragraph, because we want to follow the court's direction not to read everything,
Right.
just trying to focus on the key aspects. Is there something in the next paragraph that also supports it?
Okay, yes. Okay. the above features attribute to the characteristics of dog bites.
Can you tell us what that sentence means? And does that sentence have any relation to the concept of pattern recognition?
Yes, it does.
Explain how.
Okay. Well, so they're talking. Well, first of all, the previous paragraph was talking about the dentition of the dogs, and how there's some variation in the dentition, and then this next sentence says the above features attribute to or relate to or are relevant to the characteristics of what the dog bites would look like.
And then as you continue on in that paragraph, again, not reading every sentence, but is there another part of the paragraph that continues over on to the next page that also supports your testimony that this is talking about pattern recognition methodology?
Yes. So it goes on to say that the puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretch lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to each other, 4 or 5 in number,
Hey, Kurt, welcome.
and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals which are not accompanied by pulling and shaking, nor by the usage of the prominent canines, and with stab wounds caused by sharp instruments.
Does what you just read establish the pattern and the pattern recognition methodology for dog
Here comes
bites?
objection.
The objection sustained asked the question differently.
I object on a number of grounds.
What do you conclude from the language you just read with regard to patterns and pattern recognition methodology?
Well, I conclude that patterns are important, and they are what I call highly representative, but they call pathognomonic, meaning that there is nothing else that causes those.
Let's focus on the word, people pronounce it differently, pathognomonic. What does pathognomonic mean in medicine?
Pathognomonic, to me, I believe it means that you can make a diagnosis based on these factors that are present to the exclusion of any other diagnosis because they are so specific.
So we talked about on your direct, and it was raised on cross, the concept of a differential diagnosis, right?
Yes. Yes.
When you have pathognomonic features, is it required to even have a differential diagnosis?
Not really.
Why?
Because the pathognomonic features mean that you have the entity or the condition that that is explained.
Does pathognomonic mean that the features themselves rule out other possibilities?
Yes, that's what I believe it means.
And is that how you interpret what the author is saying in this article?
Yes.
Please proceed lastly to the next 2 paragraphs, and then we can move on to the next study, I believe.
In conclusion, to identify a lesion as a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff abrasions, include a puncture wound and sometimes an avulsion with irregular borders resembling a dental arch print.
And could you please, as the last paragraph will focus on, read what you consider important in the next paragraph?
The shape of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it mean to you when the author says, and will differ whether or not the full dentition was used to produce them?
So what that means is that if the bite does not include the full, well, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes.
Is this support for your pattern recognition methodology?
Yes.
Is it direct support for the pattern recognition methodology you have applied in this case?
Yes.
Is there another article? You mentioned two. You mentioned de Munich and Pollock. So let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34.
We're monitoring the news that there are some fires that have broken
And is
out
this the
in
Pollock,
Malibu area of California.
P-O-L-L-A-K, study that you have mentioned multiple times in your testimony and that's in your report?
Yes.
Please,
really
like we
curious,
just
I can
did with the
send
de
the link
Munich
so you can watch all
article,
of those cameras.
please identify the portions of this study that support, you've testified, support your pattern recognition methodology.
Okay.
And let's
Well,
do
start at the
a
beginning.
seriatim from the beginning.
Yeah,
Yes,
I'll do it
please.
from the beginning. So, the
Starting
dog's
at the
front-
beginning
so
is
the
a very
first
good place
paragraph,
to
okay.
start.
The summary?
Yeah, it says summary. Yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, arranged in curved lines. There seems to be a word or two missing.
No, you missed a word. That's
I
okay.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds on humans there's a pattern?
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of key words when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time and with the court's permission, to the next section of this article that supports your opinion that there is a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2.
And what is the title of that section?
Morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically it means form.
And could it mean something in addition to form?
Form, pattern, appearance, yes.
So, with regard to morphology section, please identify the sections, the parts of the article under this section that you believe, that you have concluded, support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is interposition of textiles in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the deceased?
Yes.
And what clothing specifically was that?
It was a hoodie-type sweater.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth.
And keep reading, please.
Okay. On the next page,
Yes.
the spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So, do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it direct or indirect support, these studies?
I believe this is direct.
And do you believe it's robust, these studies, or do you believe there's equivocation with regard to pathognomonic features?
No, I think it's robust, and these articles are cited elsewhere.
And
don't think you could have
these
the
articles,
same
particularly the
conversation in front of a
Demunic
jury.
article, is the citation ubiquitous in the medical literature, or is it sporadic?
Ubiquitous.
Are there a lot of citations to Demunic in the medical literature, or are there only a few?
There are quite a few.
And
He's
do you
pulling out all the
recall
big words.
book that Mr. Brennan showed to you earlier on in the hearing?
Yes,
Does that book cite to Demunic as support for a section in the book?
it does.
Now, there was confusion. You can put those studies to the side for now, Dr. Russell. Thank you.
There will be a test at the end.
Now, there was
spelling
some
test, so
confusion
please
on
take
cross-examination regarding where these articles could be found. Some were looking for them in your CV. I'm sorry, Mr. Brennan.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Redirect.
Sure. I will, Your
You
Honor.
can't do commentary.
Where are the references? Well, are the references to these articles in your CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an accurate statement about how you develop your pattern recognition skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay.
And just ask the question, please. Again, this is redirect. It's not cross-examination.
Understood. Yes, understood. Thank you.
Can't lead.
Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of a wound?
No.
Prosecutor's like, I don't remember saying
Would that be an accurate statement at all about how you develop pattern recognition skills?
No.
And why is that not accurate?
Because pattern recognition skills are, again, taught in various subjects in medical school. And I actually started even before medical school. But in medical school, they're taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please give some examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break, right, Doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Russell. This is about you, and so you've heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, have you ever gone to see the dog in question?
No.
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
No.
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
No.
Is that a rational proposition?
I don't believe so.
There was much discussion. Well, let me strike this. You were asked a number of questions about whether your testimony here for this hearing and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So, what I would like to do is to have you have Exhibit 35, which is the transcript of the December 12. Do you have that? It's a thick, it's the December 12, 2024. You should have that.
I do.
Okay. And what I would like you to do is to also have available Exhibits 35 and 36 and 37, because that's what we're going to do side-by-side comparisons. So, let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
They're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Now, at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to tab 36.
Deborah, thanks for gifting 5 memberships.
1-30, line 13 to 1-31, line 1. Stop it. 1-31, line 1. These were questions in response to what you were asked on direct by Mr. Jackson. And I would, with the court's permission, like you to read the question and the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
Ooh. The judge calls a sidebar after he announces his intention to go through line by line with what the prosecution asked to basically rebut or expand the question to allow her to give a full answer, I think is what she's going to do. And she's like, wait, we need to talk first because I don't want to rehash everything. We'll see how that goes. Kurt has a birthday soon. Happy birthday soon, or soon happy birthday, I should say. Kurt, as long as you're here first thing in the morning on your birthday, we will sing to you. We sing to everyone who has a birthday every morning. It does require getting up nice and early. I'm not sure if you're in Central Time right now, I think. So that'll require a little effort on your part, but it's a small price to pay considering you get sung to. So, yeah, it's exciting. The catch is you also have to come on the other days and you have to participate and sing to everyone else. That's the deal. Oh my goodness. See, Cheryl yesterday watched the sentencing for the Wagners. Crazy. The judge was not a fan of the prosecutor. That was bad. That's terrible. We watched that together and it floored me. I've never seen a judge, to at least to my understanding, take out his frustration with the prosecutor so much on the defendant. And when he's mad at the prosecutor and he takes it on the defendant, they get a light sentence. I've never seen it happen like that before. That was my understanding. Birthday's on Monday. Kurt, have a good one. Going to be 44. Kurt, you're just a child. You're just a youngin'. I got you by a few years. No one's commenting it. Mel, it was so bad. First of all, the audio was terrible. Okay, so that was a problem. It was hard for anybody to watch because the audio in the courtroom was just awful, and it was throughout the entire trial. You're talking about the Pike murders, right? Pike County murders. It was a terrible trial. The details were awful as well, and nobody could hear it. So I think that's why nobody talked about it. She was rewatching it, JoJo. It was not yesterday. There's nothing usually in courts in the U.S. that happens on a Sunday, unless there's a jury sequestered and they might be deliberating over the weekend. Yesterday was Monday. Didn't happen yesterday. I mean, on a Sunday. Yesterday was Monday. Okay, so yesterday went by really fast. Probably because it was Mrs. R.A.'s birthday. That's what I was thinking. But the sentencing happens last week, right? Today's Tuesday. Now I've got everyone confused. I'm sorry. Yesterday was Monday. Today is Tuesday. I think you mentioned though that it was a rewatch. Melissa P, love this community so much. Thank you for all the continued support and prayers. Pathology came back stage 3. Oh, so please keep prayers coming. Melissa, you and Matthew will be in our prayers. Thank you. Congratulations on 12 months. You're amazing. Hang in there. You guys are doing great. Yeah, it was a rewatch. Oh, I think we're coming back here. Pike County is wild. I think someone up high told the judge they want it all tied up in the rearview mirror out of the public eye. The judge took people who had agreed to testify for the state. This is in the Pike County situation. Took people who had agreed to testify to turn state's witness as part of their deal. Said, once you testify for us, we're going to sentence you, and you might get some leniency if you help. They haven't testified yet against the dad. That trial's still upcoming. And the judge says, never mind, we're just going to sentence you now, and we're going to treat you as if you helped us then. What is their incentive to comply against the dad at this point? What, is the judge going to be like, wait, I re-sentence you? No, that's not going to happen. It was wild that he just cut that part off. The son that got up and preached a sermon.
Yes.
Dr. Russell, first of all, do you recall in questions on cross the claim by Mr. Brennan, or the statement in his question by Mr. Brennan, that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion? Do you recall those questions?
Yes.
Do you recall, well, let's go and look exactly at what you said in response to the question that Mr. Brennan raised, that was raised by the judge. If you could turn to Exhibit 36. And if you could read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct citation. I want you to go to, did I say 37? I wanted to say 36. Did I say 36?
You said 36, but you said page 151. You might have meant page 131.
Right. That's what I want to go to, Your Honor, which I will. Okay.
That's what he said. He said, bear with me.
Bear with me a moment, Your Honor. This is going to be one of only 2 questions in this area.
He's warning everyone. He's got to bear. I wonder if he keeps and arms it.
You may have meant page 130. That's where we started before we came to sidebar.
Thank you, Your Honor. What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150. Thank you, Your Honor.
151.
Judge, why don't you just ask the question since you know where it is?
Can you go to page 151 and read the questions from the court, Judge Cannoni, and what your answers were?
Yes, from line 10. The court. Question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion? Answer. Yes. These injuries in the arm are, my opinion, is that they are the result of animal bites or scratches. Question. Do you know what kind of animal? Answer. Yes. Most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty. Very sure, high degree of medical certainty. Question. Reasonable degree of medical certainty? Answer. Yes, definitely. Question. And okay, and another question.
No, that's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer-reviewed studies, and I was convinced that I was correct.
And had you looked at what caused you to go look at the peer-reviewed studies? What were you
yes.
doing?
Well, so I looked at the peer-reviewed studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer-reviewed studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No.
But you were asked to write a report after June of 2024.
Correct.
Now let's go to. Is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is. Is that something that's common or uncommon in the medical community?
That's very common.
I only have a few more questions, Your Honor. I'm just looking at them to conclude. On cross, you were asked about whether you were aware of or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes.
Was that necessary?
No.
Why not?
Because first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue, is I wouldn't even know who to send it to because I don't know of anybody with such experience.
I am going to, let's assume hypothetically that Mr. Walsh has stated that
getting some lag here.
These injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, the wounds to the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern, and so thus couldn't really even make that opinion, and just didn't recognize the features.
In the hypothetical that I just gave you, do the facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree with that statement? Or the conclusion? Would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
Sorry.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up until the point, the mention of the taillight.
Right. But what is it that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found on the decedent? Are you aware?
Not on the decedent.
On any aspects of the decedent's clothing?
Yes.
Here's where the pig ear comes in. Dog chew toy?
Do you know, from your experience, with regard to dog-inflicted wounds, your many, many emergency room evaluations and treatments of them, whether or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that the dogs, some dogs eat treats that have the pig chews and other kinds of chews. So yes, they do. Some dogs do eat things that contain pig.
Yes, was the answer.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm done.
Why don't you come to sidebar instead of having a discussion across the court?
Judge, there's no jury. There's no jury here. Can we just have an open discussion instead of a sidebar every time? We want to know. Inquiring minds want to know. Carlites didn't have pig. Boston wild boar. Delicious. Let's give it a second. Let that sound. Hoping it gets muted here, but it's not. She doesn't want us to know. Oh, okay. Pickled pig's feet was was in the front yard. Oh. I have a pig ear in the cupboard right now. As someone who eats hot dogs is completely grossed out by pig's feet, I don't think I could get pig's feet for a dog. Do they like him that much? I always thought like a nice steak. A dog would like a nice steak better than pig's ears. Taking a look at all these fires, the UC San Diego cameras from California Alerts. It's crazy. Alert California is the website. ops.alertcalifornia.org/cameras is what I'm watching. And you can just scan through and see all the different fires. It's not looking good down there. The smoke's going completely horizontally, sorry. And just high winds, dry, and everything's on fire.
You need a moment? Okay. Thank you.
He's having a moment.
I'm holding Mr. Brendan up. I just
That's
want to
okay.
move my stuff, and I'll be ready in a moment.
Okay.
Dr. Russell, Attorney Alisi, pardon me,
Recross
asked you
now.
about
Or is
Dr.
this
Walsh's statement about the cause of injuries. Do you remember? He just
Yes.
asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons and known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection, Your Honor.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes.
The documented changes in color, swelling of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis is a passive accumulation of blood around the eye secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes. The 1 centimeter laceration of the right upper eyelid, laceration of the anterior right tongue, then abrasion of the anterior and left aspect of the nose are documented, considered nonspecific, and may have occurred to a variety of mechanisms. Do you agree with that?
Yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted from impact of hand with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Okay. When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that up, you said individually none of those wounds could you say to a reasonable degree of medical certainty were caused by a dog. It's only if you looked at them collectively.
Yes.
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
No.
It doesn't tell you if they're all incurred at the same time, does it?
They were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No.
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart? Table 2.
That's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case,
That's
isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim. Does it also say examination of the victim?
I don't have it in front of me anymore, but...
Well, you relied on it. You don't remember this?
I think we have it. We don't have it.
Oh, I do? Do I have it? Oh, yeah, it's a minute. Okay.
Table 2,
Okay.
page 98, examination of the victim. You did not examine the victim, did you?
Table 2.
Yes,
No.
table 2, page 90. And the last part is examination of the...
I examined photos.
The last part is examination of the dog. You did not examine Chloe, did you?
No.
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
Those, again, the purpose of this article was about the fatal, how to, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those 3 things, did you?
No.
Okay. The shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what you
shards.
say.
How many shards were in that sweater?
Objection, Your Honor.
So, I'm sorry, you said that's what you say, Doctor? Is that what,
Yeah,
is that
and
what your
he
answer
said,
is?
Mr. Brennan said that the shards were in the exact same location as those wounds.
Okay,
And
let me
that's-
rephrase that. The shards in the right arm of the sweater, the shards from the taillight that was shattered,
Yes.
those shards, how many were there? How many
I believe there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told
This is you were told by who?
by defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I was told, yes.
Wouldn't it be more prudent to actually look at the criminalistics report and make your own determination objectively and medically rather than regurgitate a point of the defense?
Well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before you offer this opinion.
No.
No. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater, in a fabric, can puncture it, and it can cause an abrasion to skin. Have you done any tests or studies to rule out that the broken taillight that was in the arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those holes. The defects in the sweater mostly were round. They were not slit-like defects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater.
No, I didn't say that. I
Like
said
a round hole.
they would not, especially on multiple sites, the same exact type wound,
Well,
defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look like that.
So from your perspective, the glass just remained dormant in the sweater but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions. I'm good.
They still want the sidebar. Wow. He tries to withdraw because he knew he stepped in it there. He's going too far. He's been, I believe, chastised by the judge at least once, where he's basically misrepresenting her testimony in his questions. So it's your testimony that the glass shards just did this, and from the accident just did this in his sweater. She didn't testify anything about the glass shards doing something in his sweater. She's here to testify about the injuries in the arm, and she says that they're dog bite, not from glass shards. But he's done this over and over. The objection came in. He withdrew the question because he knew he was wrong. Okay, he knows he's going to lose this fight at sidebar. He's like, I'm done. I got my jab in. And defense like, no, we're taking it up to the judge. we're gonna get your hand smacked again. Yes, that is John's brother in court. His mom is there as well, I believe, on the far left. Looks like it was a quick one.
Dr. Russell, when I'm referring to these shards, and I've said glass shards in Mr. O'Keefe's sweater, a more accurate way to define it would be that these were plastic shards, the plastic covering of the taillight, not glass. Okay?
Okay.
Okay. Thank you.
Dr. Russell, you are all set.
We're done?
We're done. You're done. We're not done, but you're done. You can step down, Doctor.
Thank you.
That concludes her testimony in the Dauber hearing. The judge obviously still has to rule on this. There might be arguments outside of her presence as well.
If counsel really can keep your, Mr. Lessie, if counsel really can keep your arguments to 15 or 20 minutes, I'll give you 5 minutes to pull them together, 5 or 10 minutes to pull them together.
Thank you very much, Your Honor.
I really can keep the arguments to 15. All right, so I'll be back out at 3:15.
All rise, please.
All right, so we get a 10-minute break. During that break, the lawyers are going to be prepping their arguments for the judge. Oh, we have a scam call. That's amazing. Hello?
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 Good afternoon. This is Pamela speaking. I'm calling to help you maximize
Pamela,
your
how are
Medicare
you
plan
doing?
during the 2025 open enrollment.
Hello, Pamela.
We have exciting free benefits like grocery savings with food and flex cards, improved vision, hearing, and dental care, plus up to $250
You can improve my
cash back.
hearing?
Do you currently have both Part A and Part B of Medicare?
Pamela, you can improve my hearing? Hello? Pamela?
I just want to confirm whether you have both Part A and B of Medicare.
Pamela? Are you there? I could use that improved hearing about now.
Yes, I was asking whether you have both Part A and B of Medicare.
And you were going to improve my hearing? Well, it's sounding better already now that you've hung up. Pamela's a miracle worker. She's going to improve hearing. Oh. It's just a bot. It's just a bot trying to get... They're not even putting the effort in. Now with computers are scamming us, and then they pass us off to scam us to somebody else. All right. It's my goal every time a scammer calls to never say the word yes, because I know they can record that and then use it in a different situation. Laurie, they get around this by just not being in the country and not giving a flying 2 hoots and a rain barrel about U.S. laws. All right, as the only fan turns, we're waiting for the lawyers to prepare their arguments. The witness, I think, should be out of the courtroom for this. I don't think she should be there. It would be awkward, to say the least, to be argued over in your presence. But what's going to happen is the defense is going to go first. I think that since they're the ones who have the burden of proof to say, yes, she's an expert, they're going to go first. They've got 15 minutes 20 minutes to present an argument to the judge as to why this witness should be allowed to testify as an expert in the trial that's coming up in April. Then the prosecution is then going to say why she should not. I expect that the defense is going to say a lot about her expertise, her experience, that there's nobody else in the country that matches or exceeds her experience in this particular area because of her training, both in law enforcement and in the medical field, and the number of patients she's treated with this exact condition, meaning dog bite. When you go to the state side, they're not going to focus on her experience very much. Instead, they're going to be talking about...
Call from?
It's Mattis.
Mattis, welcome. Let me just finish my thought here, and I'll give you a second. They're going to be talking about the fact that there's no set pattern. There's no set steps you follow to say follow this step, and then yes, that proves this is a dog bite. That it's all sort of subjective and it's just sort of wishy-washy. It's they might use the term pseudoscience or something similar to like that. But they want to discredit her and basically say, yeah, you've done a lot of this, but it's basically like fortune telling. Is what they want to present the judge with. And it's like, yeah, you really can't believe those people. So, Mattis, how are you doing?
Frohes neues Jahr, as we say in Germany. I'm doing pretty well.
Oh, I didn't know what that meant. I was like, well, up yours too. No, I'm just kidding. No, welcome. I'm doing pretty well, I guess.
Yeah, I'm doing pretty well. I adopted 2 cats a month ago from a woman who unfortunately couldn't continue to to take care of them. Fortunately for me, they're pretty amazing.
Mm-hmm. Good. Cats are nice.
Really, so I'm usually very busy around this time of year from work. They've definitely made it much more tolerable. And right now, one of them is playing with a toy in the corner. It's very sweet. I wanted to call you and talk about a couple of things. So first of all, I think we will probably see a very different style of cross-examination if this goes to trial, because I think in many ways, like we had about 4 to 5 hours of a very confrontational deposition. Mm-hmm. Some of the arguments that the state kind of implied there, I think that's an argument we don't make in front of a jury. Like,
I'd agree.
Oh yes, doctor, you don't even know if he was holding perfectly still while being mauled by a dog. You're just speculating. I'm very intelligent. That's not an argument you make in front of a jury.
I love your American accent, by the way. That is fantastic. You mimic
I don't
it so
know what
well.
accent that is. That's just a boastful person.
This is your real voice. You're not really German. Is that what we're hearing? That was really good. I agree.
Yeah,
We're going to see a different style of presentation in front of the jury, although there might be some snark still and some gotcha because it is sort of a battle of wits back and forth. But it's different outside the presence of the jury.
Yeah, it's going to be more concentrated. This was really going on as it was a wide net. And so I think that closing arguments here, the state kind of, they really were fishing for cross material. I don't think there's really any legal basis to deny her testifying. If you recall, it's been a while, but if you recall what the qualifications she testified to, you can just spend a couple of minutes and saying, okay, here's her training experience, expertise, qualifications, whatever. And then, she is ultimately, the question is whether she's allowed to give a opinion as an expert on whether something looks like a car accident or a dog bite. Yeah. And come on. It's basically a done deal.
Yeah, she is a shoo-in for that. But the points that they're going to raise with the fact that this is not peer reviewed, that she hasn't had any other people in her field look at this and agree that there's nobody else that looks at this, that there's not a not a pattern. What was the other word he used? The process and procedure for identifying the steps you take to identify dog bite. She's like, you just have to sort of take it all in context. It does weaken her position a little bit.
Yeah, but if you recall, the MedMal trial we watched,
yes,
a lot of doctors there also said, well, none of these doctors, most of these treating physicians didn't testify that they got a second opinion. It's just not how that works. It's about how they used training experience, like what criteria they recognize, etc.
Yeah.
And speaking of that trial, the appellate docket has gone kind of crazy since late December.
What is up with Maya in that trial?
So a lot of it was kind of normal. They granted oral arguments for February 12th. They said, okay, you can have 30 minutes each. And then there was a motion that I didn't understand, motion to substitute counsel and from the Kowalskis, and I didn't know what the point of that would be.
They brought somebody else in to argue that?
Late December, there was a note by the clerk, order to file a response. It basically said, so no, some of these motions are filed under seal, or basically they're not visible to the public. It says the Kowalskis filed a motion to substitute counsel. In it, it is indicated that Gregory and Jennifer Anderson opposed that motion. They're ordered to file a response by, I think, Monday or Friday. And so there has now been something filed, and then an amended motion, and there's the response, a notice that they filed that they amended it, and then the amended thing.
So Nick is back. Anderson is out.
That's one possibility.
That's huge. How do they, when this eventually pays
nobody
out?
Knows what it is.
How does that get split?
There's just no way to know what it is about. But apparently there is. So that's like that's the one possibility for which we have some indication. So that could totally be it, that Nick Whitney is back. It could also be something entirely different. So I have no idea. We'll see if the docket suddenly says Nick Whitney is added. But
next filing from defense will have a signature. So that's going to be pretty quick to figure out.
So the other thing is also by the Kowalskis, motion to relinquish jurisdiction and remand to the trial court. That means they have something they want Judge Carroll to rule on for some reason.
Relinquish jurisdiction from what? Who has it now?
They don't want the appellate court to hear the case, to hear a dispute in this case. They want Judge Carroll to rule on something.
Well, they did really
basically, that's what you did. If you recall the murder, where he appealed his conviction, and then he filed something. Actually, we want to go back to the trial court and ask for a jury interview. That's what you would do usually. You wouldn't ask the appellate court for a jury interview. You would do that with the trial court. So they have something they want Judge Carroll to decide. No idea what it is. Could be about the argument between the Anderson and Nick. It could be anything else.
The Andersons and Nick, they did have a falling out. He left the company, and it sounds like they're not happy. Look, Judge is back. Mathis, I'm going to let you go. Thank you very much.
All right, did counsel have enough time to pull your thoughts together?
We'll see you.
All right. Have a great day, everyone.
Okay.
Bye.
All right, Mr. Brennan, it's your motion, so I will hear you.
Oh, Brennan goes first.
I agree with the judge, Mr. Brennan.
He was surprised by going first.
I'd like to start with a couple of very important cases for your Honor's consideration. The first is one out of the District of Massachusetts Federal Court.
Please go to the microphone.
It's 55 Federal Supplement, second, page 62. It's a 1992 case, authored by Judge Berger. It had to do with a soft science, handwriting analysis. It was a very thorough and thoughtful case that talks about
pseudoscience,
soft sciences, methodology, and when there is an absence of methodology. In that case, I'm sure Your Honor is aware, it had to do with a proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science. Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, is not a science. It's not a methodology. It's not medicine. It is a personal aside. A potential expert has to be in a better position to understand. That means there has to
Sorry,
be
you guys can't see this, can you?
some level of methodology, some type of guidance, some type of study, so that they can assist the jury in better understanding what they believe their conclusions are. Empirical is not enough because
Who's watching the
subjective
fires?
opinion
Sorry.
without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experience as an ME. She treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education. She doesn't have the qualifications. She doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book. She doesn't have a study that teaches her how to. She never took a training. She never took a class. She never got a degree or certificate. She is looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there is nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity, what is the standard, and we still don't know. After all of this testimony, we don't know. In Cromwell versus Rintala, that case had to do with a prosecution expert talking about paint spill, and this is could not fit more closely to this case. The conviction was overturned because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites, a person with their past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or a particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi, pardon?
Rintala.
Thank you. In Rinaldi, direct the court to page 39. And it talks about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Cromwell versus Franceschi. Probably saying that wrong as well. But what that quotes is, while training and experience, to which the expert referred, might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody go before a jury, and portray themselves as an expert when they have no methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based. It can't be compared. It can't be analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what they're saying. A witness is prone to change their opinion because there is no standard or methodology to confine them. A witness can just change their mind without new information because it suits their purpose. When we looked at Exhibit 5, and we actually broke down the wounds into separate wounds, 5 wounds, the doctor, I believe, concedes when you look at each of those abrasions independently. She cannot say with scientific certainty. She can't say with any certainty that those were caused by a dog. Her fallback was when you look at the entire series of wounds, that equals a dog attack. No basis, no reason why we reached that bridge from uncertainty to dog attack other than just because she said so. That can't be challenged because there's no methodology. And so the risk we have is you have an expert who gets up in a voir dire and they give opinions that wound number 1 could have been teeth marks, could have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3 the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report and consulting, and she is emphatic that these are not scratches, but that they are dog bites. Think about the posture of that. If she is now saying that these are dog bites and they're not scratches, and she's changed her opinion, that impliedly concedes that her testimony in front of the jury, for which she was allowed to testify as an expert, not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they, later on, without any real changes in information, changes
got buffering
their
on the
opinion
feed
for whatever reason. They're not constricted because there's no methodology. Opinions she no longer endorses or stands behind. And the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support. And she does not. There is no doubt about one thing. She has no idea. When I walked her through the different wounds on Exhibit 5, I invited her to explain to Your Honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal, empirical history dealing with dog injuries in the ER. And when I asked her for wound 1, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of those wounds, how could she reasonably and fairly say they were caused by canines? Any indication, any support, any pattern recognition that would tell us that was caused by canines, and she couldn't give us any information. Not weak information, not information that I could fight with another expert, not information that I could say, wait, not the admissibility. None. She could just fall back on, well, when I look at everything, it's a dog wound. Same thing with number 2. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is in any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally different. And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? she would only give us a conclusory answer. It just is. There was nothing about teeth or detention or about the dog, about anything that would support the claim that that was a dog bite and why she changed it from the scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could move, wouldn't move. Yet she has no idea. She has no factual support for this. None. And she vacillates between this being potentially bites, scratches. All 5 of the different points on wound number 3 could be canines on both sides, or maybe there was a 4-point canine in a smaller fraction of number 1 and number 2 in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle, the depth. The canines are not going to move. Then we get to wound number 4, equally baseless. Wound number 4, at first, wasn't sure if it even had to do with the dog attack. But then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And then wound number 5, again, a 4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim that it's a dog bite. Not just that there was no opportunity and that there was no dog that touched her, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence that wholly contradicts the fact that this is a dog bite. She didn't know that there were plastic shards in the sleeve of his arm. The fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there isn't mere coincidence. It isn't mere coincidence. It's exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the stand and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA, or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the chronosis reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support.
I think it's 20 minutes.
This witness has the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. Knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free rein of an opportunity to look at the exhibit and tell us anything she wants to support as a dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 has 0 value. So 5 times 0 is 0. Cumulatively does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding to car accidents. She may have been a police officer, she treats injuries at the hospital, she is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology, no facts, and ignore reality and say this couldn't have been a car collision.
These are some strong arguments.
It's funny that as a
strong
emergency room
statements.
physician, she considers
I think it's a poor argument.
the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, as she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with any no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works. And so when we consider not only what she doesn't know, but what she chose not to know, it is overwhelming. This is not a qualified person to come in and talk about dog bites. From her perspective, she's probably one, if not a few people in the country who can even do this kind of thing, which suggests that there is no real methodology. If she is the only expert in the country, it is not generally accepted in the community. It can't be. It can't be. And as much as the defense may want her to testify to promote this theory, she does not have the credentials and qualifications to do that. She didn't even take the basic steps, as you'll see in some of the literature, of going to the dog. Chloe, they knew we found Chloe. They know we've done molds. And she says they told her. And she tried to fight with every posturing angle that may be important, but she didn't need to do that. I dare say, if she had taken some steps to try to do due diligence, it wouldn't have ended well for her theory. Perhaps that's why she didn't. She doesn't have the qualifications, she doesn't have the experience, she doesn't have the methodology. Her willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA, there is plastic shards in his arm. She has done no due diligence. And she can't describe any methodology because there is none. And she, most importantly, has changed her testimony from hearing to hearing, and we should not let that happen again. Thank you.
Thank you very much. All right, Mr. Lessie.
Thank you, Your Honor.
Thanks for using the microphone.
The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses is to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and tell you exactly where I'm going to go. I'm going to go to why we're here and what the issues are for this motion. So I'm going to start my argument with what is the legal standard that Your Honor faces to answer. And I know Your Honor knows it. I'm just doing it for the logic in the presentation. I'm going to go through that. I'm going to identify specific case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced, it's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology. I'm going to go through and say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. So let me start out with the baseline for this hearing. The January 20th transcript,
you can't do this
page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it.
Testimony I'm going to what? And
went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law.
We dropped
Mr. Brennan and I agree on one thing. The Rottola case is relevant. But respectfully, Mr. Brennan went off in a tangent. Because what does Rottola stand for that's relevant here? Quote, the crucial issue, in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony? It's what are the cause of the wounds to the decedent's right arm. I submit that if you ran an artificial intelligence program, you couldn't come up with a more perfect witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, forensic trained pathologist who has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Vail that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% her favor, and I don't believe you could find another witness more qualified. And that's the crucial inquiry. What's the second prong of the inquiry? After qualifications, is the methodology reliable? That's the second. Whether Mr. Brennan agrees and 95% of what he argued, that's for cross at trial. But more importantly, that's for a jury to determine. That's the job and province of a jury, to determine whether, assuming Mr. Brennan ever gets a doctor to come in and counter Dr. Russell, it's for a jury to decide which expert do we give more weight to. But the focus of this hearing, why are we here? The second prong is the methodology. Mr. Brennan, 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology.
A 29-year
Your Honor
experience
sat and
doctor
heard
with
the
dog
same
bites.
thing that all of us heard.
Named Dr.
She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. Demunic and Pollock. And we walked through, with your Honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic.
Oh, another
this
word
pattern
added to the list.
is so specific that it almost by itself rules out anything else. That's the definition of pathognomonic. And that's the definition, and Dr. Russell used highly characteristic, but she did note and explain what another study said was pathognomonic. It's incredible to me that it can be stated that there's no methodology here and that there's no basis for it. It is generally accepted in the medical community. That's the purpose of the Pollock and the Demunic article, is to establish that it is accepted. Dr. Russell is not coming here to the court and just testifying, it's my subjective empirical statement. Mr. Brennan tries to do in his argument exactly what an expert rejected and for which he has no support. And that is to say, we got to look at these wound by wound by wound, and he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is the pattern. You look at these all together, and it's the pattern that matters. And the authors, Pollock and Demunic, say that pattern is pathognomonic. You really don't even have to go to other causes, although Dr. Russell said she did. So it is incorrect that Dr. Russell didn't explicate a methodology. It's incorrect that she didn't explicate that there's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan cited to a paint case, etc., but interestingly, and in contrast, in our papers, which Mr. Brennan has had for almost a month, and he didn't respond, interestingly, we cited to the Lobello case, the Brinker case, both of which are dog wound injury cases, not pain cases. I know a little bit about Lobello because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations, including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so there is a dog bite case from the Southern District of New York, not an insignificant court, as recent as 2023.
They're insignificant courts.
A doctor that sees and treats all these, that's reliable. And this was a Daubert challenge, Your Honor. This wasn't an incidental question. The challenge was defendant's motion to preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts it's Daubert-Lanigan. You can satisfy Daubert, the federal, but you also Lanigan, and under Davis you can have generally accepted in the medical community as well. There's one case. Another dog bite case we cite, Brinker, that Mr. Brennan didn't address is a federal court case in Indiana where same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason, which is a good segue now to Massachusetts cases. Mr. Brennan's hypothesis is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog bite case. I want to be clear about that. But it's a burn pattern. And here's what the court said. The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case, I've already given you 2, but a firearm examiner in that case. The court said, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever, and in the 2 cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology, and that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor has required, a medical doctor that is required under law in Massachusetts.
Huge box of pencils.
I also, Your Honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, the Commonwealth further attempts to criticize, or excuse me, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. How does that square with Your Honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what Your Honor might do. So, in terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your Honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now a very important, in my judgment, Your Honor, legal point.
He's running out of time,
too. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it, and sustained it, and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover
I don't know if that'll stick, but it's
a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunick and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis, but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
No.
I'm sorry, 30-minute mark.
You passed 20.
The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter-argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle accident, and she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. And my last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's docketed, but I filed a notice to the court regarding my concerns about ARPA witnesses, and the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
All right. So let's set a date for a Daubert hearing.
That'll be a fun one.
Any idea how long you expect it will take regarding the digital evidence expert?
About 4 hours.
Well, Your Honor, when you say a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can set it. Well, then we'll stay now and do that.
Okay.
Are you ready to do that, Mr. Jackson?
We just got this on January 31st.
Okay.
We have not had an opportunity to respond to it.
December 31st, probably.
What did I say?
January.
Yes. On New Year's Eve. We've not had an opportunity to respond to it. We expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple of weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
No, so what I'm saying is, file your paperwork.
Okay.
All right? We'll set a date for a hearing.
Okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them on Mondays or Fridays for you, thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so...
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all counsel have that date cleared because it was a trial date at one point in our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
On all witnesses, not just, you said you're filing...
The only one he's got is for Rick Green.
What did you file a notice of, you said today?
I noticed that I expect that I will likely move to exclude the ARPA witnesses at failure to comply with Rule 14. It's not a Daubert hearing.
Okay.
It's compliance with Rule 14.
Okay, so that's different.
Yes. I am waiting for a response from the United States Attorney's Office that I'm supposed to expect next week.
Okay.
If that changes my position, I'll notify the defense and the court. If it doesn't, then I'm going to pursue that motion.
Okay.
Aaron, may we be seen briefly at time about scheduling?
All right, so scheduling, the judge's main priority here is to keep that April date for court, saying you can ask for more time, say you need more time to respond to this, but it's all got to fit in this window. Everything has to fit in this little window. We're not pushing the trial date. So this Daubert hearing's got a little long in the tooth. Is there an outcome to today's hearing? There is, Vern, but I doubt we'll hear it today. It will probably come by way of a written decision by the judge, probably in a few days or a couple of weeks. wants to exclude the entire defense's case. Yeah, they're attacking the two strongest points the defense had. Is Corey Richards in April as well? Oh, man. I need to buy some tickets. Let's see. Corey's April 28th. So they're going to overlap. I tell you, I'm excited. I'm excited to see these two attorneys pitted against each other, as well as Yannetti and Jackson. These are really, really good attorneys. And Brennan is also really, really good. I like to see good attorneys face off against each other. I like to see it with a fair fight, with referees that don't lean their hand on the scale one way or another. Nebraska girl, I've got to figure out if we're going to be there or not. It's quite a matchup. Yeah, this is the Super Bowl. This is a Super Bowl of court cases, really. Book Hermit, welcome. Good to have you here. Yeah, we're gonna have amazing trials this year. Some big trials. When is Koberger? Summer. Koberger comes in the summer. It's like a chess game. Very much so. August 11th for Koberger. BK is this year, Mary. I thought it was this year. Unless they moved it again. Lori Daybell's represented herself. That's going to be a train wreck. That's going to be an awful one. Koberger in August. It's up in Idaho. November? No. I think it's... The dates, the ones that are far out, those can still move a little bit. Lori Vallow's trial, the one we're talking about, is in Arizona, where she is going pro se. And it's going to be just insane. Let me see if Siri can do this. Maybe Grok will tell me. Grok's been really good as far as an AI.
Clear. The 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. And February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over so we don't have what happened with Dr. Russell, such a big gap in between. Okay? All right, we'll see everybody then. Thank you.
No decision today.
Thank you, everybody.
Yeah, no decision today, and that was as expected. Is she out? Yes, she is out. She's free. We'll see a decision. I don't think the judge will rule her out. I just don't. The problem is, even if she didn't like her, even if the judge wants her to keep her out, I don't think there's a legal argument she could make to support that decision at this point. January 31st, February 7th are the dates. Yes, January 31st is the first meeting to see if we need to have the other one, but that's where it would be. I'm getting a call right now from somebody. Let's see.
Call from
AWOL.
AWOL Podcast. How are you doing, my friend?
What's up, Scott? How you doing? Merry Christmas, even though it's old, but Happy New Year.
Oh, thank you. Thank you. Same to you. How are you doing?
Pretty good. Just got out of work. I want to touch on one thing before the new trial starts.
Mm-hmm.
Remember when they keep saying how fast the car traveled? If they're basing it off the spinning of the wheels, which the car would register in its ECU system, if it was snowing and you've driven in snow, I'm on the East Coast, I've driven in snow, you could hit the gas, then your wheels would spin at an alleged 35 miles an hour.
Yeah.
But the vehicle itself might not have been traveling.
It may have been holding
at
still.
35 miles an hour.
Depending on the vehicle. There are some vehicles that a lot of times I think it's the front tires that measure speed. And if you have a rear-wheel drive vehicle, your back tires could be spinning and your front tires not moving if you're stuck in the snow, and then you would not register the speed. But if you're front-wheel drive vehicle, and it also is where the speed is measured, you could very much. I've been up to 60 miles an hour in a car that's not moving because I was just floored it and just the wheels were spinning.
Correct.
It was a contest to see how fast I could get it going. But
I feel in the first trial that wasn't brought up. Like I don't remember any expert that had to deal with the information on the vehicle testifying, or any attorney asking, but what if?
I think it's because the snow came later.
Mistaken.
I think it's because the snow came later.
That was another question. Did it? Because when they left the bar, wasn't it already snowing?
I think it started snowing, but it hadn't stuck on the ground. So it might have been wet, but not. I don't know. It could have. I'd have to look at that again. I think most of the snow came afterwards. There was very little snow under his body, if any. I think. And
that's right, because that was another thing. There was grass under there.
Yeah, but if he was alive,
double parked,
his body temperature would melt snow underneath him as well.
That too. So I wonder if this new evidence, with the other computers in the car, if that would shed any light on this.
If it turns out to
I'm
be
waiting for that.
I would love it. I'm excited to see new evidence, especially on the vehicle. I like seeing hard evidence instead of what the state's put together is just the story. I don't think is right. However, they want to say it happened. I can't see the pieces fitting together like that with the evidence that we have. So that puts me in the probable doubt category, and I'm still on the not guilty side. But
right, and I heard I was watching this morning, but I was working, so I can't comment or anything. Right, and what you said with the new evidence and the pieces of the puzzle that you said, they're trying to fit, they don't fit in my mind. I just don't see it. How? And if that's reasonable doubt right there, I just don't get it. I can see it, but the percentage is really, it's like a unicorn. It's like, wait, what had to happen? Everything had to happen in a perfect sequence of events for this to be so it happened this way. I don't know if nobody knows.
The pirouette, the spinning around in the air.
Yeah, you said that. We're all speculating, and I understand they're doing a job, defense and the state. I'm not mad at either side. This is your job. You're doing your best. But I just don't see it. If I'm in the jury, I'm like, I don't know how this happened. I can't send her to prison if I'm like, I don't know, and I don't think you know.
No, I
Not you, Scott, but I'm saying,
definitely
like, the
don't know.
attorneys.
I can tell you that.
No, not you. That's why I clarified. Not you. I don't understand. Like, if I was in the jury and the state attorneys and the defense, I'm like, I don't think either one of you know. So at this point, I would have to go not guilty. Because if I'm at a I don't know, then it should not be guilty, because that's not fair. If you're at a I don't know as a juror, you got to go not guilty, because the state has a burden of proof. And if they have me at a I don't know, then it's not guilty. I'm sorry. You should have did a better job, or this is what you had to work with. At the end of the day, I don't know what happened, and you didn't prove it.
Yeah.
So not guilty.
We should all start at not guilty. That's the point, that every defendant starts at. They're not guilty as we start out. And the state has to move us off that position. So.
Correct. Well,
good thoughts.
Nice talking to you.
As always.
Wish you all the best. I'll talk
thank
to
you
you
very much.
soon, man.
We'll see you. Bye.
Yes, sir. Yes, sir. Later.
All right, Josh, I'm trying to, while I was talking to AWOL, I was trying to look at this. He's got a little tiny thing he wants us to watch before the end. He says it was really funny. So let me jump over to see if I can pull this up. This just happened yesterday. 23rd District Court. District Court Judge Slavin. There we go. Got him. He got a little one hiding under a book so you can't see him. We see you. Hiding under papers. Okay, this was... one day ago. Josh, do you have the timestamp of when? It's 2 hours and 45 minutes long. Hey, Mrs. R.A. I see you.
Stop looking.
Stop looking. No, I like looking. I'll look at me instead. How about that? Oh, wow. How'd they end up there? Okay, give us just a second here. I'm trying to find this guy on the stream. It's a solve sit, so we always like the solve sits. Please stay live for 25 more minutes while I'm in the school pickup line, says Tish S. That line sucks. Let me just say, it doesn't get any better ever. It's year round. It's a terrible line to sit in. Josh, do you know where on the video it is, about how many minutes in? I'm trying to scan. It's not the whole thing, is it, Josh? Hold tight, guys. This might be worth it. Let me fix my little window that I was in. There we go. I'm back. Josh's finds are worth it. Yeah, if you've been here before, you know that when Josh has a suggestion, it's worth listening in for. And I have been watching the fires. I can't show you much of it, but there's all sorts of cameras showing fires all over in California. And it's scary. It's scary. They're predicted to have winds in the 80 to 100 mile an hour range. And when you have dry weather and winds at 80 to 100 miles an hour, that's an inferno. It's a firestorm where, I mean, it's just the smoke is blowing horizontally. Just it can't rise fast enough. The wind's just blowing it straight across. No pressure, Josh. Okay, 21 minutes, 32 seconds approximately. That works. I can get there. 21:32 roughly. Back up just a tiny bit. Here we go. All right.
Okay. There's no communication between the two.
Josh's fines are usually worth it, so we'll see if this is a good one. Waiting for the next case to start.
Next one.
I think this is him. Top right. Am I hiding the judge? I am. It's okay. You know what judges look like. I rewound just a couple seconds before this, so we got the intro. Turns out that was not needed, but we'll wait anyway for the judge to get started. Who's that guy in the seatbelt? Was he like in the Death Star or something? It's a weird background. Mel's temporarily quit smoking to watch this, Josh, so it better be good. Oh, man, the linemen out in California have a tough job for sure. Yes, this guy does have a long history being a soft-sit on firing attorneys, so we can only guess how wonderful this one's going to be. Judge, that's your timer. It means we should start now. Uh-oh. If he's right there, I need to move. Think I could go up and sit in the attorney's box for a minute? Just right up here. I won't take much room at all. Judge is like, okay, we're ready. Let's try this.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Eric Martin.
Okay, so the other one
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge. Donna
Judge.
Sobe on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
He's like, I've got history.
Right,
This is
your
a bad
motion to
one.
withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's in this state making false statements here talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me, so.
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court. and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything, and you keep doing all your little negative comments, things that you want to say about people. You think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know, but you don't have the first clue when it comes to things, and you talk about that. And so Mr. Gizicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. All I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney. But I want to state also that if it was recorded, it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this. Do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without. All
right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now.
Please do.
So we're going to appoint another court-appointed attorney to you.
The goat is ready to let loose.
And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try, I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
It's not so much a calendaring thing. It's like,
are you really? I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold
on. Judge hung up. The judge hung up. He kicked him out of the Zoom room. I got some questions.
You are so released. I'm going to ask that the clerk reach out to the indigent defense group and the individual who was here at that trial. Let's see if we can appoint him. Mr. Martin doesn't have any qualms, I guess, about him. So
somebody asked for the goat. There's the.
I'll let the record reflect that almost anybody who has passed the bar exam is qualified to practice in the state of Michigan. Got a criminal case. So.
You got the regular goat and you have the Christmas goat. My Christmas goat has fresh batteries, so it's pretty good. My old one has lower batteries and is a little quieter, but I think with new batteries, they're both pretty loud. I will tell you that I did earn last month almost $60 from Amazon.
Stop ticking.
Mostly from commissions
on the
from
Motorola
selling from you guys who bought these
Razr
goats.
2023. What is your name?
That's the most I've ever seen.
Amanda Brown.
Before. Had dozens of those. You guys ordered dozens and dozens of those.
All right, Miss Brown. I have a court-appointed attorney for you. I got you checked in. I'm gonna put your name in here.
We're gonna
check in.
bail on Miss
Clerk will
Brown.
eventually get into pulling you in there and making sure.
Yeah, we're gonna bail on Miss Brown there. She's just glad that the judge can just let it all go after the soft sit. Man, he is not putting up with that. That was pretty funny. Josh, you did well again, as always. You came through in a pinch and delivered the goods. We appreciate that. We sort of needed something lighthearted like that after a pretty lengthy and somewhat frustrating hearing with Karen Reed. That was a difficult hearing to sit through with some difficult attorneys. Let's put it that way. A difficult judge. Everything is difficult about that case. But it's all good. It's all good. We appreciate it. It was a good palate cleanser. All right. So I don't know what's on the schedule tomorrow. I haven't looked that far ahead. I'm not sure. Oh, I think we've got in the Tennessee case, I think we've got jury selection starts tomorrow. So we'll have to look at that. I heard it was moved to October 20th. Which case was that? Quick, Josh, find another one. Tish, are you still in the line? I'm babysitting tomorrow. Wagner, possibly. I might want to jump in on the CNN case. I want to look in a little bit on that. It started. Day one was today. Might want to see what that is all about. It might be too much politics and pickles in there, but. Stabby suitcase trial we were just about to look at. Is that the one that starts jury selection tomorrow? Tennessee. Yeah, it's Tennessee. Yes. Okay, so jury selection usually is not televised. I don't know how long it's going to take, but it's something we'll keep an eye on. We'll probably, if they're doing jury selection, we'll probably have to do court hopping until they actually seat a jury. Sometimes when they do jury selection in the morning, we start in the afternoon, which is great if they're able to seat a jury that quickly. Other times we do jury selection for 2 or 3 days and then start the next week. What is the CNN case so I can look it up? That's all I know is that there's a CNN case out there, and I don't know how CNN is involved. 80s Music Man, I'm babysitting myself. They'll be busy. It's a defamation, CNN defamation. Ooh. The news did a story about somebody that turned out to not be true. The news, but it's on the news. It's got to be true, right? All right. Well, that's as far as we go. It's a defamation case. So it's civil? It's got to be civil. Chan versus Tennessee. That's the one that's started with. Thank you, Red Pen, for that one. All right. Oh, my goodness. I'm not sure how long the line is going to go for the school pickup, but hopefully your kid comes out quick. I know. Kids and children are different. Kids are baby goats, but Pickles, not a good case to cover for the channel, says they will. Okay, lots of politics on that one. I think you accidentally turned on your goodbye music. Could have been worse. I could have turned on verdict music and had you really confused. It's been a wonderful day. I appreciate you all being here. Thank you very much. It's been good. We are closer to having a case that we can follow for multiple days at a time. The same case all the way through, gavel to gavel. It's coming soon. I think we're through most of the holidays, and we'll get back into that regular schedule. We'll probably be at the point where we have too many cases to follow at the same time, and that's fun as well. But until then, tonight when you go home, please hug the people you love, smile at someone, and make their day just a little bit better, and please stay safe till we go live again tomorrow morning about 8:30-ish. And we'll see you all till then. Please stay safe, guys. Have a good one.
Don't miss the forest through the trees.
in front of the Walmart